Most professionals who come to me already have strong incomes, established careers, families who rely on them, and assets they've spent decades building. And yet, most of that wealth is typically just sitting inside of a single legal system, usually a revocable living trust sitting here in the United States. What most people don't understand is that asset protection is not just one thing or one document or one trust. It's a layered, structured approach to holding your assets in a certain way that creates a certain outcome. And how effective any particular asset protection strategy is a function of what type of layers you're using, how many layers you're using, and how much diversity you can get into both the layering as well as the jurisdictions. And of course, making sure that the assets are in the structure that you've created. So in this video, I want to walk you through 3 of the most important layers that I use to help my clients protect their assets. This is built for the real world, not a theoretical textbook asset protection structure. And it also really looks at the diversification of jurisdiction and how being completely within the borders of the United States is very limiting to your asset protection structure. And we'll talk about how being inside one jurisdiction, particularly the United States, can leave you still very exposed. We'll talk about how having just a single jurisdiction, particularly the United States, can expose you to far more risk than you ever thought really was possible. So tier 1, having multiple jurisdictions. In other words, having assets actually outside of the country. So this is a big one because even without a really dedicated asset protection structure, I have clients come to me all the time and they'll have a piece of real estate in Costa Rica or in Caribbean or in Europe, and they'll say, do we need to protect that further? And the answer is often, yeah, we need to look at it. But the reality is for many of those clients, just having the assets out of the country, particularly real estate, is a huge barrier because a court in the United States trying to get through a foreign legal system with a judgment in the US to reach an asset can be incredibly difficult. In fact, I have many clients who have real estate in countries like France, and they're just trying to sell it. There's no creditor, there's no issue. They're just trying to sell it, and they have difficulty in their own right selling their own asset. So the legal systems of Europe in particular are very old. They're very antiquated. In France in particular, it's a civil law system. In fact, much of Europe is civil law, Germany, and as opposed to common law. The UK, where our legal system comes from, is common law. Common law means we do have statutes, we do have a civil code, but we also have cases which help fill in the gaps in between all the civil statutes and regulations. In a civil law country like France, it is just the civil law. There is no case law. They do not rely on another judge having thought through a difficult problem that had fallen through the cracks of the civil description of the law and said, okay, well, here's our reasoning why, and future courts can use this as guide or precedent. In a civil law country, you just have to rely on the code. And if the code is not exactly on point, what you end up with is often a big mess. And when it comes to things like real estate or assets in those countries, I've seen people who have inherited property from relatives in jurisdictions that are not the US that have taken years, I mean, downright years, to get legal title clear to property that they've inherited. And there was no question, it was not like an argument of inheritance, or if it was really theirs, it was just getting through the legal system. So in that respect, just having assets outside of the US already can be a huge deterrent when it comes to a US creditor thinking of assets that are available to them to satisfy a judgment. So important to understand, because if we then take that concept of having foreign asset, which is already difficult, and then combining it with the next 2 things that I'm going to tell you about, you're going to see that it becomes nearly impossible for a US creditor to reach an asset that's sitting outside of the US in the correct structure. So let's talk about offshore bank or brokerage accounts as opposed to real estate. So certainly real estate, difficult to get because you have a legal title system and it's not liquid, and selling it can be very difficult, getting authority to sell it, etc. But what about a bank account? Well, bank accounts are similar in the sense that if you have a foreign bank account, it is still not often subject to the US courts or the US judgments. However, it's cash or it's liquid. And so a judge here could simply tell a debtor, in other words, somebody here who owes a debt to a creditor, once they find out about that foreign bank account, to simply liquidate the account and send the money back. So in other words, they don't have to fight through a foreign system to get the money. They just tell the US debtor, you better bring the money back. That's why a bank or a brokerage account in your own name in a foreign jurisdiction is not very protective. Unless no one knows about it, which it's very difficult to have no one know about it, because you're going to have to go through a disclosure process, potentially a debtor's exam or interrogatories or other legal process that would elicit the fact that you have a foreign account. Once the judge knows about it and you have direct control of that account, you could have trouble because the judge can just say, hey, bring it back. I'm ordering you on threat of contempt of court to just simply bring it back. So problematic, but again, there's a solution and we're going to talk about it. The other thing about having foreign assets in this world today, where there's a lot of uncertainty, having assets in a foreign jurisdiction, whether it's real estate or a bank or both, in potentially a foreign denominated currency like euros or pounds or yen, then you have some diversity and you have some backup. So let's just say we had a 2008 style financial collapse of our banking system and we had some type of freeze on assets, maybe globally, or maybe something that affects all of us. Having assets in a different jurisdiction could be a solution to that. That's why a lot of people keep some physical gold and silver in their possession or easy to reach, so that if we ever did have a system failure in a complete way, you'd still have something to trade with. That's not a primary reason necessarily, but it's definitely a secondary thought of having something outside of this country that you can access that's not necessarily tied to both our dollar as well as our financial system. And I've talked about this in the past. Our financial system is built in a very leveraged way. It's called fractional reserve banking. What that means is that banks don't have to just lend out what they have. They can lend out a multiple of what they have, basically a factor of 10. So if a bank has $1 million on deposit, then they can lend out $10 million and just keep a 10% reserve. And that's called Tier 1 capital reserves. Most banks in the United States have Tier 1 capital around 10%, meaning they've lent out 10 times the money that they actually have on deposit. The reason that we feel secure with this is that banks have the backing of our federal government, the FDIC. The challenge is that the FDIC itself doesn't really have any major reserves that it can bail out a bank. It's going to in turn just turn to the federal government. And as we saw in 2008, this was okay and it worked as long as the banking failures were kept to a minimum. We just had a couple of banks fail. I mean, Lehman Brothers failed. Merrill Lynch was required to be bought out by Bank of America because it effectively failed. Some other smaller institutions had real troubles. But if we have a global financial failure, then the Tier 1 capital reserves of just 10% could be insufficient, as opposed to banking in other jurisdictions around the world, particularly Switzerland, where it's not the same. They don't have the same type of fractional reserve banking. What they have is trust banking, meaning they're actually, when you deposit money in a Swiss bank, you're depositing it in a segregated account, which is not able to be lent out by the Swiss bank. We consider a brokerage account here in the US, which also is a segregated account. In my opinion, I prefer to keep any significant money, in other words, over $100,000, $200,000, definitely anything over the FDIC limit of $250,000, in a US brokerage account, or even more secure would be a foreign Swiss bank account. It shouldn't be in your own name, it should be in a trust. Particular type of trust, which we're going to talk about, but it's definitely important that if you're trying to diversify, that you look at the whole world nowadays, from a currency standpoint and from a banking infrastructure standpoint. So I would encourage you to think of having foreign assets not as a loophole, not as some kind of, oh, I got out of something, but really as a reserve, as your own reserve nest egg. Just having assets offshore is already a very strong fact pattern. Beware, there's still compliance with assets offshore, any type of assets offshore, whether it's real estate, less so, but bank accounts for sure. You have foreign account tax compliance. It's minor, it's no big deal, but it's very important. If you don't do it, there's penalties. So you don't want to miss it. It just means that you have to tell the IRS, hey, I've got a foreign bank account, there's this much money in it, so that they can be looking if you've earned any interest or dividends or gains in there, that they can tax it. Remember, as Americans, we are taxed on worldwide income, global income. Unlike other countries, we're taxed on all of it. So you have to comply and you have to be compliant. So it's very important. But there's nothing illegal about it. There's not even a red flag about it. In my opinion, based on 30 years of seeing people and helping people with offshore, I've really seen no instance where just having an offshore bank account or an offshore trust itself triggered any kind of red flag or audits from the IRS. There's a lot more things you can do domestically that will trigger that before you ever have to worry about having an offshore structure be a red flag for you. So if you do want to see how exposed your assets really are, I have put together a 7-minute asset exposure test. It's free. You can click the link below and get access to it. I encourage you to do it. Take your time. It's very easy, but it will help you see what's protected and what's not protected. And understanding what's not protected helps you understand where you would experience pressure first. In other words, where you're vulnerable. And that alone is valuable. And again, many people discover that a lot of their assets are already protected under exemption statutes like the homestead exemption or qualified plans, 401ks, etc. So just knowing that can bring you a lot of peace of mind. You may not need to do any asset protection. So click the link below if you want access to that. So tier 2 in our structure is using holding companies to create separation and segregation. So what does that mean? What that means is that if you take assets and you put them into separate boxes, you can increase the protection. And then if you take those boxes and you layer them in other boxes, and think of these boxes as safes. So, right, if you create assets and you put them in a multiple of safes, and then you take those safes and you put them in another even more secure safe, that creates an asset protection structure. So how do you do that? Well, you do that with legal entities. And when I say legal entities, when a lawyer says legal entities, what they mean is LLCs, companies, limited partnerships, and trusts. That's basically the world of legal entities. So the most common, the one that many of you listening to this may already even have, is what's called a limited liability company. And LLCs are great tools. They're a much more modern tool than corporations, which are very old. A share or a stock corporation has been around for 100 years plus. However, LLCs have only been around for 40 years. They're fairly new in the world of law, and they were actually designed to be a better instrument than a corporation or another structure like a general partnership. The reason limited liability companies are good is that they have been designed to protect the members from the liability associated with the asset or the business held in the LLC. That's a good thing. Corporations also do that. But corporations are different because a corporation is just an asset. It's a share. It's a stock. It's a certificate. So if you have a creditor and you have a share of stock in Google or Apple or Nvidia, and that creditor has a judgment against you, that creditor can actually take your share of stock in Apple and say, hey, that's worth some money. I will use that to pay back the debt that you owe me. That's the problem when you use a corporation, a privately held corporation, whether it's a C corporation or an S corporation. If you use a corporate structure, you are just creating another share type of asset, which can be taken from you by a creditor. We don't want that. So to solve for that, you have two options. One is the limited liability company, and the other is the limited partnership. And they're both very effective at protecting because they don't have shares. They don't have any kind of share or asset that a judge can reach. You are either a member of an LLC or you are a partner in a limited partnership. Both a member and a partner are things that can't be taken. In other words, you can't take my partnership from me because the partnership is an agreement. You can't take my membership from me because the membership is an agreement, much like being a member of a country club. You can't just take somebody's membership in a country club and go, hey, I'm the member now. No, you have to go through the application process. You have to meet the qualifications. You have to meet the rules, and you have to be accepted. So it's the same in an LLC. You have to be accepted. And you know who's not accepted in a well-drafted LLC? Creditors. That's who's not accepted. So a well-drafted LLC and a well-drafted limited partnership are going to be not available to creditors. So if you are a member of an LLC and that LLC holds real estate that has value, then if you have a creditor and they get a judgment against you personally, they can't just go in and grab your LLC shares because there are no shares. They cannot become a member in place of you because the LLC operating agreement says they cannot. We do not accept that. You cannot be a substitute member. You can only be a creditor. In other words, you can only get an interest or a lien or a charge against the interest of the LLC, which is a membership interest. That charge, often referred to as a charging order, is what the remedy is for a creditor against an LLC. So why am I going through all this? Because LLCs are a great first layer of asset protection. That's going to be the very first thing that we look to when we're designing an asset protection structure. What are we going to put in LLCs? Well, we're going to put assets, and in particular, risky assets. Risky assets are assets that in and of themselves can create liability. So a real estate is a risky asset. A rental property is a risky asset. A car is a risky asset. An airplane is a risky asset. A boat is a risky asset. A business is a risky asset. All these things are risky assets, which means that you want them isolated. You don't want them exposing you to liability. And so you want to put them in an LLC. You also want to protect their value from your exposure to liability. So you go out and get into a car accident. It exceeds your insurance. And now they have a judgment against you. And you have 14 properties and they have a combined total of $3 million of equity. Well, that judgment creditor from the car accident would love to go in and just grab those 14 properties and pay themselves the judgment. And if you have them all in your own name, that's exactly what they'll be able to do. But alternatively, if you have them in LLCs, most commonly will be multiple LLCs, not all 14 properties in a single LLC, but maybe you have 5 or 6 LLCs comprising those 14 properties. Now the creditor is not able to get into it. So what can the creditor get? They can get a charging order against your interest, but they can't foreclose on the underlying asset and directly get the assets themselves. In other words, they can't get the real estate. And again, when I say can't, I mean that's the general rule. That's the law in general. This is always with the caveat that a judge can ignore the law, or they can come up with a legal theory that would allow them to disregard it, like alter ego or piercing the corporate veil. So you always have to be careful. You can't just assume what I'm saying is legal advice that's going to apply specifically. I'm talking about the general rule here. But the general rule is a good one, and we do want to utilize it. So the first layer of your asset protection structure, the first tier, is going to be a series of limited liability companies holding your real estate, holding your businesses, holding your airplane, holding your boats, holding your collection of ATVs and stuff that can hurt people. What you don't need to have it hold is your bank accounts and your gold and your cryptocurrency, because those aren't risky. And we also definitely would not want to mix those in with an LLC that holds something risky. So if you have an LLC with a nice multifamily eightplex, and then you have $1 million of cryptocurrency, you would not want to add both of those things into the same LLC. Why? Why would you not? Well, because if the eightplex causes a liability, there's a fire, somebody dies, and that same LLC also holds the $1 million of cryptocurrency, guess what? The $1 million is exposed to the liability of the eightplex. If the eightplex is in its own segregated LLC and it has a liability, now it stops there. You've isolated it. You've compartmentalized it. So very important that when you're designing a structure, you understand compartmentalizing assets. Now, you don't necessarily need to compartmentalize every single separate asset. It's more a concept of an amount of money that you're comfortable in each particular asset holding company. So if you have rental properties and they're very small, let's say they're small little homes and they each have $50,000 of equity and you have 5 of them, you might just put all 5 into a single LLC, particularly if they're all in the same state. So, however, if you have a strip center and you have $1 million of equity in that, well, that definitely would demand its own separate LLC because there's enough equity there. You don't want to mix it with something else. So, okay, now that we have all your LLCs set up, what are we going to do with them? Well, we don't want to hold them in your personal name, because that's not enough layering. That's just one layer. And so if a judge pierces that veil, which again is always possible, can't say what a judge in the US is going to do. If a judge pierces that veil, then it's right to you again. And so we don't want that. What do we want? Well, we'd like a holding company. Now, a holding company can be another LLC. That's an acceptable holding company, or it can be a limited partnership. I personally prefer the limited partnership, because you're getting another type of legal entity involved. It's actually an older legal entity. It's been around longer than LLCs. It has a distinction between the general partner and the limited partner. And this creates some advantages, particularly when we get to the third step, which we'll talk about, which is the trust. And so I like an LLC at that first layer and then a limited partnership at the second layer.
I call the limited partnership I use an asset management limited partnership because that's what it's doing. It's managing your assets. Now, what's it going to hold? It's going to hold all the LLC interests. And if you're a single member in those, meaning you own them, they're not with a partner, then those LLCs can remain single member, with the single member being the multi-member limited partnership. Why is this an advantage to you? Well, it's an advantage to you because if you have single member LLCs, you do not have to do separate tax returns. So if we go back to our 14 LLCs that you have, if you have 14 multi-member LLCs, guess what? That is 14 1065 tax returns. That's a lot of tax returns, and that's going to be a lot of accounting cost. However, if you have 14 single member LLCs and one multi-member asset management limited partnership, now we're talking about one partnership tax return, and it will do the accounting for all 14 of the LLCs. Much simpler, much easier, much cleaner for your accountant, for you, for your bookkeeper. So that's the structure that I prefer, and most every CPA that I work with also prefers it. So, and that's something that when we work with clients, we always try to include their CPA and help them understand how this is going to affect future accounting. And virtually always CPAs are pleased. They're like, oh, thank God, I've been trying to get this thing organized for years. So usually we're very friendly and very fans of each other when we meet the CPAs of our clients. So once you have that, what else goes into the asset management limited partnership? Well, that's where the liquid assets can come in. So this could be the cash, the stocks, the bonds, the cryptocurrency, the receivables, the gold, the silver, all of those things, because they don't have a risk component. In other words, they don't hurt anybody. You can't hurt anybody with your crypto wallet. And so you're not going to get sued because you injured somebody. Whereas if you have an apartment and it burns down, you can get sued because the apartment burned down and somebody got injured, but not true with a bank account. So safe assets, which are all those things I just talked about, can go directly in the holding company. Or in some cases, we might put them in its own separate type of LLC holding company, which in turn is then in the asset management limited partnership. Again, depends on your circumstances. You're always going to want to talk to an attorney to help you design it exactly right. So the net is that the virtually all of your assets are now sitting in a holding company, either directly or through the various LLCs that are underneath the holding company. And this does a couple of things. It gives you a nice, clean tax return, very easy accounting. You can do one single set of books for all of them. You can have different accounts for each property. So you set up your books right. This is going to be clean and easy and very efficient. But you're also doing something else very important. You're creating a place in which you can attach the third tier, which we're going to talk about. So let's talk about jurisdiction within these tiers. So if we're talking about the first tier, the LLC layer, and let's talk about mostly real estate. When you have real estate in a jurisdiction, let's say it's Texas or it's Florida or it's California, and you create an LLC to hold that real estate. When you put the real estate into the LLC, that LLC, whether it is a domestic LLC, meaning one in the state where the real estate is located, or a foreign LLC, meaning a Wyoming or Nevada LLC or a Delaware LLC or even Alaska LLC, that you now bring into California, let's say, to hold the real estate. When you do that, that LLC is now doing business in that state. And when it does business in that state, it's got requirements. So it's got to register to do business, which means that foreign LLC has to be registered in California to do business. What's the business it's doing? It's holding investment real estate. That's the business it's doing. That investment real estate is physically located in California. Therefore, there is no chance that you can argue that that foreign LLC, call it a Wyoming LLC, is not doing business in California. It's holding California real estate. So it is absolutely doing business in California. So the question is, well, what law would a judge in California apply to an incident that occurs on the property? Well, as you probably would have guessed, the judge is almost certainly going to apply California law because the LLC is holding an asset in California, a piece of real estate. It's renting it out in California. It's subject to California law. It is renting it out to a California resident, so there's jurisdiction. So when you are talking about that first layer, I look at the asset. I determine, is this asset going to be subject to the law of the state that the asset is located in? If so, then I use an LLC in that state. And that's simply for convenience. You're going to use an LLC that is easier to set up and maintain because it's already going to be in the state where the asset is held. It's going to be familiar to the title companies and everybody else who needs to deal with it. It's already going to be subject to California law. And so there's no real advantage in using a foreign LLC, like a Wyoming LLC, and then having it come into California and hold California real estate. All you're doing is now subjecting yourself to maintain an LLC in 2 states, Wyoming and California. And I get a lot of people confused in this. They think, oh, I did a Wyoming LLC. Even though it holds California real estate, it doesn't have to pay the California franchise tax. It doesn't have to do anything in California because it's foreign. And it's going to have Wyoming law to protect it. No, it's going to have California law because it's doing business in California. So my general rule is that I will use an LLC in the state the real estate is located. So if it's in Texas, I use Texas. If it's in North Carolina, I use North Carolina. If it's in Florida, I use Florida. So that's rule number 1. Rule number 2 is once you have that LLC in that state registered and the asset funded in it, somebody needs to own that LLC. Well, we already established that's going to be the holding company. That's going to be that asset management limited partnership. That does not need to be in the state where the real estate is located. In fact, you might have many LLCs in many different states with different real estate, but when they go into that holding company now is not directly doing business in those states. It's just holding an asset, or it is a member of an LLC, which in turn is doing business in that state. So this is your chance to use one of those good jurisdictions like Wyoming or Nevada or Delaware or Arizona or Alaska. Those are some good jurisdictions to use for your holding company. And what you're looking for in a jurisdiction is exclusive charging order remedy. That's what you're looking for. So you want a jurisdiction that recognizes only the charging order as a remedy for a creditor against a limited partnership or an LLC. And so there are several good states, the ones I just mentioned. I personally like Arizona because it's very, very easy to maintain. Arizona does not require an annual report or even an annual fee. And so every other state I mentioned does require an annual report and an annual fee. And I cannot even tell you how many times I've had clients call me who've done a Wyoming or a Nevada LLC. They got behind on the filing, they got behind on paying the fees, and now it's defunct. It was administratively dissolved. They didn't realize it. And now 5 years later, they want to use it because they're being attacked and they realized it's not even valid. So it's very important if you're going to do any entities anywhere that you keep them maintained. It's critical that your structure is maintained. My personal philosophy is the minimum number of moving parts that make it work. So as simple as you can make it, the better. So the more complicated, you might get theoretically more protection if you do more and more complication, but you're also doing more and more complication, which gets harder and harder to maintain. So you just want to balance the complication with the effectiveness and the practicality of maintaining these structures. Because remember, this is not a 1-year plan. This is something you're going to keep most likely for the rest of your life. You're going to keep it till the day you die, and you're going to pass this structure even on to your heirs. So I think it's incredibly important to create a structure that it's going to have maintenance, but at the minimum amount of maintenance that you can get is the best. So that's the first 2 layers. And you have done a really effective job if you've done that, and you have several LLCs segregating your real estate into tranches or pieces or sections of assets or levels of assets that you're comfortable with. It might be $250,000 per LLC, might be $500,000 per LLC. It might be $1.5 million per LLC. Kind of depends on you, your assets, your risk tolerance, how much in assets you have, what type of assets you have. You might have assets where the lowest amount of equity you have is a $1.5 million. Like that's the smallest asset. Well, then your LLCs are going to be $1.5 million each. You might have LLCs where you have, very small little chunks of equity, $50,000 per house, in which case you'll have more options. You can decide to put 3 or 4 or 5 houses in a single LLC, or you can decide to break them up. Let's take a minute and talk about series LLCs. This is a big deal because some jurisdictions came out with something called a series LLC. And what a series LLC is it's a single LLC under a statute in a state that allows for it, like Nevada, for example. It's a single LLC that is then allowed to create series. So you register the LLC once in the state, and then you, without any further registration, just create additional series. So you would say series 1, and then you'd put 1 rental property in it. And then you would say, okay, series 2, and you put the second rental property into it. If it's created properly in a state that actually has a statute, then these series are all protected from each other. So an asset in series 7 does not affect the other assets in series 1 through 6. That's as good as having 7 different LLCs, and yet you're only maintaining one LLC. So when is a good time to use the series LLC? Well, a good time to use the series LLC is when you are holding assets that are in a state that allows for series LLCs. And that's the trick. And that's why I see a lot of mistakes made with series LLCs. People don't understand that you cannot use a series LLC from Nevada, which does allow them, and then take that to California and create series 1, series 2, series 3 in California. California doesn't recognize series LLCs, and so they would simply see it as a single LLC. And so all that segregation of the assets in the series that you thought you had doesn't exist. It's gone. So very, very important if you're going to use series LLCs that you use them properly and that you use them in the right jurisdiction that allows for them, and you make sure they're using it for assets that are in that jurisdiction. Finally, I mentioned passing your assets at your death. Really, there's no better way to pass your assets than already in an asset protection structure. That is the best way to pass your assets, because if your children are going to keep the assets, they're going to want to have them asset protected themselves. So having them be passed an LLC that holds a rental property is much, much better than having them pass the rental property directly. Then they're going to go, okay, well, what do I do? How do I protect this? And probably end up putting it in an LLC. So having assets that are already structured properly and protected and layered like this is a great way to pass assets. It's also a great way to pass assets to multiple beneficiaries. In other words, if you have several kids, and I see this a lot with clients, they'll have 3 children, let's say. One of the children is very into the property. So they like managing it. They got involved. They are participating. They're learning the business, where the other 2 are off doing different careers, right? They're not in that world. But when the parents die, they want to pass it equally to all 3 kids. But only one of the kids wants to actually manage it. That's a perfect structure to do exactly what we've already talked about. Have an asset management limited partnership as a holding company, and then multiple LLCs. The child who is going to be the manager can be the general partner of the holding company or the manager of the managed LLC, whatever we're using. And then the other 2 siblings can simply be members or partners and receive distributions. So it's a great structure for passing assets to kids. If you're going to liquidate the assets, it's fine. You just liquidate them. The other important thing to note is that when you use pass-through structures like this, when you use LLCs and limited partnerships like this, what you're doing is maintaining the step-up in basis. What is the step-up in basis? The step-up in basis says that when you die with an appreciated asset, your children or your heirs receive that asset and they get a step-up in the basis to the fair market value of the asset today. So I'll give you an example. Let's say your mom bought AT&T stock a zillion years ago, right? She put $10,000 into AT&T stock. It's now worth $4 million. And they've never sold it, right? All these years, it's split, it's doubled, it's gone ever. And so now you've got this massive pile of AT&T stock from your parents. And when you sell it, there's a capital gain. So if your mom had sold that stock that she bought for $10,000 for $4 million, you'd have $3.99 million of capital gain, which you would have to pay tax on. However, if you die with that same stock and your kids inherit it, that $10,000 basis gets stepped up to $4 million. Now your children could sell that stock and pay 0 capital gains tax. So the step up in basis is very, very important. It's something you want to maintain. Having your assets in pass-through entities like limited liability companies taxed as partnerships, limited partnerships taxed as partnerships, and grantor trust maintains the step-up in basis. So your accountant is going to be very happy. Your estate planning attorney is going to be very happy. And this is very important when passing an estate. Okay, so now we've got asset management limited partnership, holding company, layers of LLCs. Now what do we do? Is that it? No, that's not it. We have one more layer, and that's called the asset protection trust. And this is a very, very important layer because the first 2 layers are still legal entities under statutes which are registered in various states. A trust, also a legal agreement, is not really an entity. It's not something you have to check the name with the Secretary of State. You don't have to register it with any state. It is a private agreement between at least 3 parties. the creator of the trust, called the settlor or the grantor, the trustee of the trust, who is the one who's going to control the assets of the trust, the third party, who is the beneficiaries of the trust. And you can have other parties like the protector, investment advisor, etc., but at least three parties to create a trust. When you create a trust, you are doing something very, very different than when you create an LLC or a limited partnership or a corporation. You are creating an agreement with a trustee that sets the rules for how the assets of the trust are going to be held and managed for the beneficiaries. So when you set up a trust, if you set it up correctly, you can create very powerful language inside there to protect those assets from creditors. So how do you do that? You do that with what's called an asset protection trust. And what an asset protection trust is it's a trust that typically the settlor or grantor sets up with a trustee for their own benefit, meaning they are their own beneficiaries. So the creator sets it up for themselves. This is called a self-settled trust. And a self-settled trust is very common. Every revocable living trust out there is a self-settled trust. That's what it is. But when you do an asset protection self-settled trust, you're doing it in a very particular way. Because one, you're not making it revocable. You're making it irrevocable. Two, you're going to use a specific jurisdiction which allows for that trust to have and incorporate these protections, which are called spendthrift protections, which is number three. Spendthrift protections are the protections drafted into the trust that protect the trust from a creditor. In other words, the provisions of the trust that say, if the trustee ever sees that a creditor is going to interfere with the distribution to a beneficiary, the trustee is directed not to make the distribution. And those provisions are very powerful when you're looking at protecting assets. So in the model of a tiered and layered and stacked asset protection, we're going to use two layers of entity structures in the US, LLCs and limited partnerships, and a third layer of an asset protection trust. It's going to sit on top of the holding company. Above it, it's going to own the majority interest in that holding company. And it's going to have those all-important spendthrift provisions and be set up in such a way as to take advantage of the jurisdictions that allow for this type of trust. So what are the options for an asset protection trust? Well, basically there are three options for an asset protection trust. You can do these trusts as fully foreign trusts in jurisdiction like the Cook Islands or Belize or Nevis. You can do them as fully domestic trusts in jurisdictions like Nevada or Wyoming or Delaware or Alaska or any one of the other 22 jurisdictions that have some type of domestic asset protection trust statute. Or you can do it as a hybrid of the two called a bridge trust, which is basically a foreign asset protection trust registered offshore, but then bridged back and treated as domestic trust for tax purposes. So let's talk about all three. The first type of asset protection trust that was ever available was a foreign asset protection trust, and the first jurisdiction was the Cook Islands. The Cook Islands are way down the South Pacific, below Hawaii, basically equal distance south of the equator as Hawaii is north of the equator. They are an English common law jurisdiction, and in 1984 they passed a statute called the Cook Islands Trust Act, which enacted a very specific statute that allowed for exactly these type of trusts to be created. This was big news. It was a very big event back in 1984. And it took at least 10 years for the U.S. legal industry to really kind of even figure out what these things were. Nobody really knew how they worked, what they were. Very few attorneys had any experience whatsoever with them. And so for 10 or almost 15 years, they were kind of under the radar. What a foreign asset protection trust does is it sets the trust's jurisdiction as the foreign jurisdiction. Therefore, that statute in that foreign jurisdiction fully applies to the trust. And that statute is incredibly strong, makes it very, very, very difficult to reach the assets of a foreign trust. So we did have cases, and very big cases, and guess what? The foreign trusts worked. They were very effective. Creditors could not reach the assets of the foreign trust. And so they started to get some traction and popularity. And ultimately, this led to some U.S. states copying the foreign model and creating the domestic asset protection trust. So what are the advantages of a foreign trust? Well, it's very effective. Because of the foreign jurisdiction and the statute and the commitment to making sure that these things actually do as advertised, which is to protect assets, they do. They protect assets. What are the downsides of a foreign trust? Well, really, there's just three downsides. One is the cost. They're quite expensive to set up and quite expensive to maintain. The second is compliance. You have a fair amount of compliance with the IRS, what's called Form 3520 and 3520A. This is a very full, complete form that has to be done every year, the penalties of which for not filing are extremely high. And the third thing is really the control of the trust itself, which is going to rest with that foreign trustee. So if you look at the foreign trusts, benefit is there, but for the average bear, for the average millionaire next door, having a fully foreign Cook Islands trust is probably a little bit overkill. A little bit too much. Now, if you knew you were going to need to use it, if you absolutely were going into the battle for your life and all your assets, of course, I would choose a foreign trust. However, if you're just preparing for a possibility that is likely not to happen, in other words, it's kind of the black swan event, then starting with a foreign trust is going to expose you to that extra cost, that extra compliance, and that loss of control. And so for many clients, it's just a non-starter, and they would rather not be protected than have to deal with those things. And so it's not often an option for everybody who otherwise really does want and need asset protection. So what about the other end of the spectrum, the domestic asset protection trusts? I mentioned that the foreign trusts were around for about 15 years before the domestic trust came on the scene. Well, the domestic trust came on the scene in 1997 when Alaska passed the first domestic asset protection trust statute. And that was a big day because all of a sudden Alaska is in the game of asset protection. And they modeled their statute very much on the Cook Islands statute. They tried to do many of the same things that the Cook Islands did. The challenge with the domestic trusts is that they are still domestic. And while the Cook Islands can say that statutorily the High Court of the Cook Islands is prohibited from recognizing any other jurisdiction's court orders or judicial proceedings, Alaska cannot say the same thing. Alaska cannot say that we are statutorily disregarding another state or the federal government. And for that reason alone, domestic trusts are already kind of working with their hands tied behind their back because they cannot do what the foreign jurisdictions can do and disregard the U.S. courts. So they gave it a good shot. And there are some advantages to domestic asset protection trusts. You do not have the foreign trust compliance, the Form 3520 and 3520A and the associated penalties if you miss it. You do still have the loss of control. Very important that the trust company and not the client control a domestic asset protection trust. The cost is less expensive, but in my opinion, the protection is just not certain enough. And so I'm not a big fan of domestic only asset protection trusts. I feel like there's just a better option. So what is the better option? The third way to do it is called a bridge trust. What a bridge trust is it's a hybrid between a foreign asset protection trust and a simple domestic grantor trust. The advantage is that you're getting the protection of the foreign jurisdiction should you have to cross the bridge, but you're getting the management, compliance, and simplicity of a domestic asset protection trust. And so you're really getting the best of both worlds. Now, is a bridge trust right for every circumstance? No, it's not right all the time. It's right about 95% of the time in my experience with my clients. The other 5% of the time, I'm going to typically go right offshore to the fully foreign trust. So in my model, with my experience, I am either doing a bridge trust, which is most of the time, or I'm going straight into a fully foreign trust. I am not using a domestic only asset protection trust just because I don't think they're as good as the other two tools. So whichever tool you end up using at that third level, whichever type of trust, fully foreign, fully domestic, or bridge trust, it's going to sit on top of the holding company. It's going to hold the majority interest in that holding company. And should you have a problem, which means some type of catastrophic lawsuit, a big accident or a car accident where it's going to exceed your insurance by millions of dollars, that's when that trust comes into play. And that trust can then demand a distribution of those assets from the holding company. And again, it's very important how you structure your holding company. Not every jurisdiction allows for this, or certainly has statutes that allow for it statutorily within the framework. That's one of the reasons I like Arizona. Arizona has a statutory framework that allows for a limited partner to make a unilateral withdrawal from an Arizona partnership upon the occurrence of a predefined event. So we can predefine an event which is attached to the triggering of the trust, which allows that foreign trustee to then say, hey, distribute the assets to me. Then you can combine moving those assets offshore with an offshore controlled trust, and you end up with all of the benefits of a foreign asset protection trust when you need it. And that's the protection. And when you take the big candy apple, the big pot of gold away from the potential creditor, and they see all those assets just not available to them for settlement or for a collection on a judgment, the energy behind someone suing you goes away. Asset protection is not about just magically making all your assets go away so that no one will ever sue you. You can still get sued. You still might have to deal with all the legal mumbo jumbo that goes with being sued. But if you can take the assets off the table for collection, the likelihood that you're going to get that thing settled much faster goes way up. And so that's what assets protection is about. That's why a layered approach is best. Because if you have LLCs and you have a holding company and then you have the asset protection trust, you're not relying on just one thing. The LLCs are going to handle many of the small claims. They won't even bother to try to break through an LLC. The holding company is going to handle an even higher level of claims because those are still valid tools that really do deter a creditor from trying to reach the assets. And then the asset protection trust is going to sit at the top, and it's going to be the ultimate deterrent and the ultimate actual escape for your assets should you actually need it. So there you have it. That is the layered approach with the three most important things, which is assets outside of the U.S. jurisdiction, a layered structured approach from the corporate standpoint of LLCs and limited partnerships, and then an asset protection trust sitting at the top and wrapping up the whole thing. Asset protection starts to make more sense once you understand that as you get more successful, you're just going to attract more attention people who might like to get your money from creditors or lawyers. And that a layered, structured approach that really gives you an out is so important to providing you the security and the peace to continue to do what you do and to make the money that you make without worrying that you're literally risking it all every time you go out there and make your next deal. When you layer the assets across multiple structures and multiple jurisdictions, you have massively increased your flexibility and your options should you end up in any kind of legal scrap. And that's important when you're trying to keep your peace of mind and continue to make the money. Distraction is the number one problem I see when people get in trouble is that they get distracted. Their money-making ability starts to go away with the level of lawsuit or attack. You see it in divorces all the time. Parties all of a sudden tank their business because the divorce is putting so much stress on them and everybody loses. So the goal is not to disappear. The goal is to create structure that allows you to control and or benefit from the assets, even if there's legal pressure, even if there's attack on your wealth. In my experience, the clients who sleep best at night are the ones that know that they built their asset protection well before they ever need to use it. If you want to understand more about asset protection or talk to us about asset protection and how it might be applicable to you, click the link below. We're happy to schedule an analysis and help you understand your options. Remember, it's your money. Act like it.